I think we have everyone here. I will let those appearing for oral argument to know. Ms. Palin, your microphone is shut down, so you are muted. You don't want to be muted if you're going first. There we go. You are the appellant. You have the ability to reserve up to 5 minutes for rebuttal. Did you want to reserve any time?
Yes, Your Honor.
How much, please?
5 minutes, please.
Okay. I will interrupt you when you get to that point. It is still your 5 minutes to use or not use. So if you wish to keep on going, you can keep on going. The clock will keep on running. If you like to stop there, I understand. The panel understands that as well. With that being said, the floor is yours at this time, and we will let you proceed.
Thank you, Your Honor. May I please the court? My name is Christina Palin. I'm arguing on behalf of myself as the appellant. The main things that I want to highlight in the oral argument, Your Honors, are the one issue is that the trial court wants you to deem a person vexatious litigant without any determination of the factors laid out in the two main cases that I've cited in my brief, which is Lomax and Jordan. Lomax is the third DCA case and Jordan is a second DCA case. And basically, the trial court admitted that it did not need to have an evidentiary hearing in order to deem a person vexatious litigant. And the one issue that was laid out in Lomax out of the 5 criteria is that the court needs to make a determination of objective good faith of expectation of prevailing prior to deeming somebody a vexatious litigant. The trial court did not engage in that process because there was no evidentiary hearing to make a determination. There was not the proper notice to appellant to see what cases were being relied on as the 5 or more cases to deem an individual, to deem appellant as a vexatious litigant. So without that criteria, then the trial court's reasoning is that I can just in a very raw way, look at only 5, go up into a litigant's history, find 5 or more cases filed within the preceding 5 years, and no matter what those cases say, unless there is a judgment in favor of the person in question, appellant in this case, then everything else had to be deemed as sufficient to use for 5 or more cases for a vexatious litigant. Now, how bizarre and how warped that analysis is evident when we look at the actual cases that the trial court used. One case that the trial court used was a settled case. It was settled between myself and the co-defendants. One of the co-defendants, actually, the notice of dismissal as to one defendant in that case was filed, but it wasn't filed as to the other one because of miscommunication between the parties. But the case was settled. The entire case was settled. How can that case be used to deem me as a vexatious litigant when the parties actually settled the case? So it's warped when you don't go in and look and dissect the case and say, wait a minute, what were the elements other than the fact that the case was just dismissed? It's not just dismissal of a case, it's dismissal for lack of merit, for lack of good faith. So none of those findings were present in the case. And the case that I'm talking about, just to make sure that the court can follow me, is the 13 CA 4514. That was what I called in my brief on page 14 as the Palin versus Staten case, STATTON. So a settled case got used by the trial judge as one of the 5 or more cases. Now, the second case that the judge used was a writ of prohibition filed to disqualify a judge that was sitting in a county case. So you cannot file a writ of prohibition in county judge. A writ of prohibition goes to the circuit court when the case involves a county case. So I'm in front of a case in a county case, and of all things, that case is someone suing me. I'm not even suing them. I encountered an issue of prejudice in the county judge, a conflict with the county judge. I file a motion to disqualify the county judge where I'm a defendant, not even a plaintiff, so I didn't even bring the action. But it gets denied in order for me to get to make full use of the judicial avenues that are open to me. I have to take the writ of prohibition to the circuit court. So Judge Holder comes 5 years later and uses that case as to deem me as a vexatious litigant as well. Again, warped and not within the statutory meaning or not within the case law that allows these cases to be relied upon as 5 or more cases for vexatious litigant determination. The third case that is used is an enforcement of subpoena. The case was initiated in the circuit court. That's the 15 CA 7063 case, Palin versus Department of Health, during administrative hearings that were ongoing in 2015. I cannot ask an administrative law judge to issue a subpoena. The only way I can do that is to ask a circuit court judge. So I initiate a proceeding to enforce a subpoena for somebody to come and testify at the administrative hearing, which is the only avenue for me. And lo and behold, that they show up. Once I file the administrative subpoena, they show up. I failed to notify the court that, hey, it's done. I don't need this anymore. So it gets dismissed as lack of prosecution a year later. And then 5 years later, Judge Holder comes and says, oops, that's another one. You were vexatious there as well. But no determination that this was just a mere filing for an enforcement of a subpoena. No objective, as Lomax says, there has to be an objective determination of the good faith expectation. He doesn't ask me, and in fact, the trial judge in this case says he doesn't have to do any of that. He just has to look at only the raw numbers, just 5 or more cases, and that's it. Then done. You're done. You're vexatious litigant for life in this state. So that's already 3 cases, of course, but the other one that I just want to talk about was the Palin versus Bishop that the trial court relied on. It was a 12 CA 12615. It was not even a final judgment. There was the final time had not even expired yet. So he didn't even use that criteria. He's supposed to use a case where there's a finality, where there's all avenues of appeal have been exhausted. It was not. Then the other case number 5 that he relied on was a case that was dismissed against a criminal defense attorney who had yet not been found, pursuant to 3.850, that he had been ineffective in representing me. So it was just because I had not exhausted the 3.850. Again, none of these cases that were looked into, not only did the trial court fail to give me notice and say, hey, Christina Palin, I have a question about the following 5 or more cases. These are the cases in the order to show cause. Before I deem you vexatious litigant, tell me what is going on with these cases. What is the thing? So I never get a chance to do that. I only see that the trial court is relying on these way after the fact, after he deems me a vexatious litigant. That's all by design. I mean, I can sit here and scream from the tops of the mountains as to why any judge would engage in that behavior. That's because this judge, he made it clear in the issuance of another portion of the argument that I like to get to, which is the injunctive sanction order. It was all based on his own personal, undetached, lack-of-neutral need to adjudicate claims and accusations of disrespect by me. Perceived disrespect because, mind you, he says I'm disrespectful, but I have no record. There's no transcript he attaches where I'm disrespectful. There is no email he attaches where I'm disrespectful. He says all kinds of stuff that I supposedly said about his wife. I don't know where they are on the record. I mean, if he hears it from a social hour from some attorney that I'm saying things about him, that is not evidence before the judge. But he uses those things that he's hearing from the environment and he attempts to adjudicate me and bar me from filing because he's got an axe to grind with me. And that is there's a long history of this court having even stayed him on prohibitions that were taken up because of just these irregularities. So that's I think that the fact that he ignored the statutory reasons to and the proper way under Lomax, and then under Jordan, where this court specifically stated merits of the claims of the cases must be determined by the trial judge before going down the road to bar a pro se litigant from filing. Just because I'm boisterous, just because I speak loud, just because I am not going to lay down and take what has happened in the past 7-8 years to me regarding my profession as a medical doctor, and just because I'm going to fight to the end does not mean I'm vexatious litigant. That just means I'm standing up for my rights. And for the trial court to prohibit me from filing because he wants to silence me is not an appropriate use of the vexatious litigant statute 68.093. The final thing that I would like to just quickly address is the fact that the trial court other irregularities that make it clear that there's something else going on here. This is not a detached judge. This is not a cold, neutral, detached judge that is no expression, no issue, just only the facts and the evidence. The trial court lacked authority he engaged in a rule violation. It was 1.54 rule violation. He dismissed the case, 15 days elapsed, and then after 15 days, he tried to breathe life into the case. I submit to this court for the purpose of going back and trying to redo the vexatious litigant thing because he knew that it wasn't right. So, but he doesn't have authority to do that. Then on top of it, he tried to hold, after he dismissed the case, then undid his dismissal, and then he tried to hold me in contempt for defending myself. He issued an order to show cause for contempt. I filed papers to defend myself against the contempt before I came to the second DCA to say, hey, he dismissed the case, engaged in rule violation 1.540, and now he wants to undo it after the time period has elapsed. So then the second DCA obviously put a stay on it, and that's where we are now. The case was on a stay because the court had no jurisdiction to proceed to a contempt hearing after it had already dismissed the case, 15 days had elapsed, and rule 1.540 was violated.
Could you please clarify for me what remedy it is you're seeking as to that issue and the fact that the judge has basically done what I see you asking for? You're saying he shouldn't have done this outside of that period of time, but isn't that in essence the remedy that you're seeking here?
Well, no, he reinvigorated the case. So he dismissed the case, then I appealed, and then he breathed life into it again, and then we're now on hold as to the contempt hearing.
He vacated the order. So what remedy, I'm guessing, I just want to know what it is that you are asking as to that point. I understand your other points, but what is your remedy that you're seeking?
The remedy that I would ask is that he not be allowed to vacate the dismissal prior to the determination, and also not vacate the dismissal and not allow me to defend myself in the subsequent proceedings. That's what I'm asking for. I'm asking for the remedy to be able to, if he's going to vacate the dismissal, okay, and go proceed with the contempt charge, that I be allowed to defend myself against that contempt charge. But by me filing papers, he says I'm violating his orders. The orders that he arbitrarily put on me to deem me as a vexatious litigant using these cases that have not been dismissed because of merit, but more because of technicalities and procedural issues. So the remedy is, the remedy is that one, the whole entire appeal asks is to obviously not allow this to stand as a vexatious litigant, to disqualify him, to that he clearly has demonstrated that he will go to a rule violation and in order to hold me in contempt. And there's something wrong with that whole entire element. That's what I'm asking the remedy for, is that he not be allowed to proceed to preside over this matter.
You are now at 15.
Okay, then I'll just stay quiet for now.
Okay, thank you. Let me mark it down here. Clear the clock. Okay. Is it Attorney Tosh? Is that correct?
Yes, Your Honor.
You may proceed.
Thank you. Good morning. May it please the court. My name is Elizabeth Tosh and I represent Leanne Gowdy as well as the law firm of Gowdy and Kahn, the appellees in this particular case. In this particular appeal, we are asking that this particular panel affirm the lower court rulings. I presume that we are having the 5-6-19 order at issue again, as well as the 6-19 order of dismissal that was reversed. I have a few main points, and I will confess I tried to make them very accessible to use within the briefing because I did find the brief filed in this appeal to be a bit confusing by Ms. Palin. My first point is there is absolutely no jurisdiction by this court to consider the issues raised in point A and point B of this appeal. These issues were already litigated in the prior appeal, which this panel heard in case 2D19-1805. I actually pulled up a copy of those briefings. I referenced it in my filings to refer back to the prior briefing and appendixes that were issued in that case. That case, we had an oral argument on, a per curiam affirmance was issued, and ultimately the mandate was issued on 4/3/2020. So our position is that on the issues of the vexatious litigant, which encompass A and B, as well as the injunctive sanction order, those are improperly before the court and there's no jurisdiction. My second point is going to be that the issue raised in the brief by Ms. Palin this time with respect to point C, the partial summary judgment on count 1 was an error. There is no jurisdiction. And furthermore, we also assert that there is a waiver due to the appeal that was handled in 2D19-1805. And furthermore, it's collaterally estopped. And finally, the point D that we're here on, which is what the actual petition was originally filed on when this appeal was initiated, where Ms. Palin is arguing that there was an authority to vacate the dismissal that was done in June of 2019. As the court has already pointed out, the trial court has already addressed that. There's no remedy that's being requested that this court can actually do to assist in this particular case. It's already been done by putting the case back on the docket with the ability to defend against it or do whatever filings she's legally allowed to do with the prior order. So I'm going to address my first point very briefly because I feel it was covered pretty sufficiently in the briefing, which is that the vexatious litigant, as well as the judicial bias, requesting that the judge be disqualified, all those issues have been exhaustively litigated in multiple petitions for relief by this particular party. And we handled these issues in the 2D19-1805 case for which the mandate was issued. The exact same legal arguments were raised, the exact same legal issues, and the exact same objections to the lower court's findings were raised. Ultimately, Ms. Palin was not successful in that appeal. She is seeking to relitigate these issues rather than accepting those results. There's nothing new here. We detailed within our brief that both the concept of res judicata as well as law of the case bar the issues that are being raised in point A and point B from even being considered by this court. They have been concluded with finality. Res judicata bars issues that were raised as well as issues that could have been raised but were not raised. And that comes from the Beverly Beach property case versus Nelson, 68 Southern 2nd, 604. It's a 1953 Florida Supreme Court case. Also, law of the case says that if you have the same parties from the same lower court case with the same appeal, if you've already done it once and it's concluded to finality, that prior decision is the law of the case, and we can't seek to undo that. And I do have authority as well that supports the position that a per curiam affirmance, which is what was done in the 2D19-1805 case, is properly considered to be law of the case. That is going to come from the New England Insurance Company case versus International Bank of Miami. That's 537 Southern 2nd, 1025. It's a third DCA case from 1988. And the case of Jacobson versus Humana Medical Plan, which is 636 Southern 2nd, 120, also a third DCA case from 1994, recognizes that a PCA is appropriate for law of the case determination. So there's absolutely no jurisdiction for arguments A and B within the brief, even though over, I think, 30 odd pages were dedicated to that. So there's no ability for this court to consider the issues that Ms. Palin spent the majority of her briefing on, as well as her oral argument. It's simply barred by collateral estoppel, law of the case, and there's simply no jurisdiction. Now, the next issue that I do want to address is her argument C in her brief that is relating to the fact that she believes that partial summary judgment that was entered on count 1 was an error. Again, there's no jurisdiction for this court to hear that. Partial summary judgment is not a final order. This is she's requesting that this court render an opinion on a non-final order. Under Florida Rule of Appellate Procedure 9.130, you can't do that. And furthermore, the case law is very clear about what is a non-final order. If we look at the SLT warehouse case, that sets out a test. And basically it says, if there's nothing else between the parties to adjudicate, then it's final. But there are things to adjudicate between the parties still, because we only have the partial summary judgment that's entered on count 1, and some of her other issues still remain viable. And as this panel has pointed out today, her case still remains pending in the lower court. So there is not the finality of the issues between the parties at this point, because there's no dismissal at this point of her entire lawsuit. The dismissal was vacated by the lower court. So it's an incorrect procedural posture to ask this court to even consider to review the partial summary judgment on count 1. And furthermore, I would say that even if this court is of the opinion that there is jurisdiction to consider the partial summary judgment, I would argue it's a waiver. We've had the prior appeal, the 1805 case. Ms. Palin could have raised it in the 1805 case. She could have raised it in any of her numerous prior appeals that we have noted exist within our briefing and referred back to in our prior cases. So our position is that it's waived. The case law on waiver is also pretty clear as well. I'm going to cite the JAB Enterprises versus Gibbons case for that proposition. That's 596 Southern 2nd, and that's a 1992 case out of the 4th District. And essentially, as we all know, if you don't raise the issue in the briefing, it's waived. So in the initial briefing for the case of 1805, which went up on oral argument, it was never raised. And she had the ability to try to raise it, and she never did. And so it's now waived. Furthermore, as a procedural point, when she filed the petition, which originally opened this case in which we're here today, the only grounds for relief which she sought was to reverse the lower court's dismissal of her case that was entered in June of 19. None of these other issues were raised, so she went well beyond the scope of the petition, which is also not permitted. Now, on the issue of point D, which is her position that she's claiming that the trial court lacks authority to vacate the dismissal because 15 days have passed. The judge issued a pretty detailed order that was transmitted by the lower court as to the nature of the mistake that was made and why the case was dismissed and why the court reinstated it. Essentially, just I think 2 or 3 days more than the 15 days passed. I think it was 18 days actually passed between that time period of the dismissal and then the vacation of that order. There's nothing to be done for that because, as you all have pointed out this morning already, that case was already put back into place. So essentially, we've now spent 8-9 months on this appeal and spent numerous hours and time and money to address an issue that was moot at the outset. She had the remedy that she wanted when the court simply vacated that order, which dismissed her case. But instead, she didn't walk away from it. She instead tried to, and is, relitigating issues that a mandate has already issued on, that this court's already considered and rejected. She's raised new issues that are improperly done procedurally, for which there's no jurisdiction whatsoever, and is seeking to use this last appeal, which is arising from orders issued in 2019, to try to undo the vexatious litigant and to try to get the judge off the case, which candidly is moot because he's now retiring as well. This whole thing is really an illustration of the fact and the reason why she was ultimately deemed to be vexatious. There's no relief that this court can give that was not already put into place by Judge Holder when he vacated that order dismissing the case and put her case back on the docket. What we would request is that this court affirm that the order that vacated the dismissal was proper and appropriate. Then we can go back down to the lower court and we can do whatever is needed to resolve the issues that remain between the parties and hopefully wrap this up. This case has been going on since 2016. Ms. Palin has been declared vexatious. She never retained counsel. She didn't comply with the terms of the order. And our position, as stated, is essentially every single issue in this appeal, there's no jurisdiction to decide it. And I thank you for your time.
Thank you, counsel. At this point, we will return to the appellant who has the 5 minutes remaining for rebuttal. You may proceed.
Thank you, Your Honor. Your Honor, it's completely baffling that opposing counsel does not mention the very order that this court issued in 2D19-1805, which I will read, that they're treating in the order, that where the mandate was issued, we treat the notice of appeal as a petition for writ of certiorari. So when it is denied as a petition for writ of certiorari, that is not a final judgment. You can re-raise those issues. That is not a determination of a merit of the case. No, she goes into this elaborate discussion, which we all know about, collateral estoppel if something has been decided, but she never addresses one point in her answer brief. And that is the fact that this court treated 2D19-1805 as a certiorari. And she wants now to overshadow that. She wants this court to overlook that it was converted into a certiorari and decided as a certiorari. And she wants to keep arguing that, oh no, it's collateral estoppel, collateral estoppel. Collateral estoppel does not work when a prior determination was made as in the course of a certiorari, unless it is specifically stated. And it is not. It just simply says that the entirety of 2D19-1805, where I was only appealing the injunctive sanction order and the vexatious litigant, was to be deemed as a certiorari. And the reason why that was is probably because the case was not yet over, and because the court, looking at 2273, which is the current appeal, realized that this is probably the final appeal. Now, as far as the partial summary judgment, of course, I wouldn't have to raise in 2D19-1805 the partial summary judgment ruling, because that was only addressing the ruling regarding the injunctive sanction order and petition for, finding of vexatious litigant. Those are the only two rulings that were being appealed, and this court deemed that to be the proper mechanism to be a certiorari and not an appeal. And so it is a certiorari that she wants you to say, because you deny the certiorari, you cannot now consider the entire issue of vexatious litigant as on the merits. So I submit to the court that it is very proper to determine that this court should not let this absurd definition that this judge imported in deeming somebody a vexatious litigant, using those 5 cases that I described to you, where Jordan, this court's case, and Lomax were completely violated in spirit and in the letter of the law. So as far as going back to the remedy, you can't just say, okay, the rule of violation is clear error of law. You can't just say, oh, okay, it was right. 1.540 was violated. He should not have reopened the case after the 15 days had elapsed. So the proper thing to do is for you to decide what to do with what was appealed in this appeal, and then return it to the trial court. So that's the remedy. The remedy is to decide what needs to happen with respect to the vexatious litigant and the partial summary judgment ruling, and then return it to the trial court. But the trial court cannot just simply dismiss. The time passes to reopen, and then just says, okay, I'm going to ignore that. I'm just going to go forward and I'm going to deal with the rest of the stuff. That would still make the rule violation to stand. So, and as far as the judicial bias, the collateral estoppel argument and judicial bias, again, I'm not prohibited from raising the issue of judicial bias on a record that is this riddled with the trial judge's personal animus into the record, talking about trying to, adjudicate matters that he believes are perceived are disrespect towards him and his wife, without even having a single piece of record. I mean, I just love the fact that this entire case just constantly makes conclusory statements by the judge saying that this is how I deem her disrespectful, finish, that's it, that's the end of the story. There's no one that can contest that. There's no one that can test that conclusion. So that's exactly what I think is opposing counsel is also trying to do. So I think I will leave it that, as I've covered most of the things that I wanted to.
And you covered it right exactly at 5 minutes.
Thank you, Your Honor.
Thank you. Thank you both for your presentation today. Please stay well, and we will move on to the next case, which I believe is Howard Avenue Station and the Dubliner.